Okay, so my Supreme Court case is Miller v. California, and this case regards the meaning of obscenity according to the Supreme Court. It also discusses freedom of speech as stated in the First Amendment. So a little bit of background. Marvin Miller was a part owner of a business, and in 1972, he decided to start a new form of advertisement. This campaign included sending unwanted letters to many California citizens. More background. A mother and her child felt offended by the letter received from Miller, so the mother pressed charges against him to the California Police Department, and then Miller was arrested under the California Penal Code 311.2, Part A. This code states that every person who knowingly sends or brings into this state, publishes with intent to distribute to others any obscene matter, is guilty of a misdemeanor. So this penal code basically says that it is illegal to distribute unwanted obscene material to others. This penal code was written based on the two previous cases of Memoir v. Massachusetts and Roth v. the United States. So Miller was originally tried by the Superior Court of Orange County. He was found guilty on the charge against him regarding the California Penal Code 311.2 Part A. And he immediately appealed this arresting and claimed that his First Amendment right of freedom of speech was violated, and that the jury instructions did not use the standards set in the case of Memoir v. Massachusetts. The standard set in the Memoir v. Massachusetts case was that in order to be judged obscene, materials must be utterly without redeeming social value. Miller argued that only a national standard for obscenity could be applied. Part 1 of the Supreme Court's verdict includes their rejection of Miller's argument based on the Memoir v. Massachusetts case. The Supreme Court felt that this previous case ruling should not affect their decision on the Miller case. After the rejection of Miller's first argument, the following major question arose: is the sale and distribution of obscene material protected under the First Amendment's guarantee of freedom of speech? So, Part 2 of the verdict is that the court ruled that the sale and distribution of obscene material is not protected under the First Amendment. Also, they ruled that state statutes designed to regulate obscene materials must be carefully limited. The First Amendment allows citizens of the U.S. to engage in freedom of speech, press, religion, and the right to assemble, as long as the general population is not in any sort of danger with that citizen's speech, assembly, press, or religion. The three criteria for work to be subject to state regulation is known as the obscenity test. This established test overturned the definition of obscenity, as stated in the Memoir v. Massachusetts case, and was created after the Miller v. California case. The first criteria is whether the average person applying contemporary community standards, not national standards, would find that the work has an excessive interest in sexual matter. There were two other criteria made for work to be subject to the state regulation. The second one is it can be subject to regulation if the work taken as a whole lacks serious literary, artistic, political, or scientific value. And the third one is whether the work depicts or describes any patently conduct specifically defined by applicable state law. Another result of Miller v. California was the Miller test, and this test takes a publication or any type of artwork and determines whether or not it is suitable for the public to see. It also looks to see if this material is or is not protected by First Amendment rights. So the Miller case really brought the idea of obscenity into the public, and there were many effects. For the first time since Roth v. the United States, the Supreme Court agreed on a definition of obscenity. However, many argued that what might be considered obscene in Utah is not obscene in Mississippi. Some other effects include that many localities have cracked down on adult movie theaters and bookstores. Also, many restrictive zoning ordinances and public nudity laws were created.